So let's move on to boilerplate contract language. So like I said before, these are provisions that are usually found in every contract. Attorneys, I say cut and paste because it's just that these provisions are important, and these provisions are broad enough to cover any contract that the attorney is really doing. So there's no point in just reinventing the wheel and retyping the information. You can just apply it. So it doesn't mean, though, that they're not important. It just means that from a practical standpoint, you can transfer this language from contract to contract. So we'll just go through these examples. A choice of law, it just dictates where the parties will litigate a dispute. This kind of goes to what somebody was mentioning earlier about doing contracts with companies from different countries. You can dictate where the parties will go to court if there is a dispute. So even if you're dealing with another company from a different country, and your company is in Florida, you can dictate that the parties will litigate the dispute in Florida. Severability, it just basically means that there could be certain parts of your contract that a judge could deem not enforceable. So remember, we said there's a difference between a contract and a contract being enforceable. So this is very common with non-competes. If you have a non-compete with one of your employees and you need to sue one of your employees or your former employee under the non-compete because they violated, a judge may strike out certain parts of your non-compete, but it doesn't mean that the non-compete itself is invalidated. So that's what this provision means. It just means that any part that's not considered enforceable doesn't mean that the rest of the contract is unenforceable. The other parts of the contract are still in place. Amendments, this is very important when it comes to leases or when it comes to any contract that where a lot of terms can end up changing. So these are for people in the creative industries, website design, or sometimes in construction, where the scope of work can change depending on certain circumstances. This provision just dictates that any amendment to the contract has to be consented to by both parties. So, and a lot of times this provision will say that any modifications have to be in writing. It's very practical because it doesn't, so that you don't have to go and you have to be in a situation of redoing an entire contract because one little provision has changed. You can just amend the contract and the original agreement will account for that and allow the amendments to be considered a part of the original contract. This last point here is merger integration. Any terms that are not in the contract are not enforceable. So the way that these two work together is that the merger, the integration clause will basically say that if it's not in this agreement in the four corners of the agreement, you don't consider it a contract, or it's not considered a part of the contract. So any emails that you are talking about going back and forth between the parties before an agreement is signed would mean that the language in the emails is essentially null and void as soon as the contract is signed. You're only going by what's actually in the contract, not what's being said.